video about civics economics. Today we're going to be going over court cases from 1803 to 1989. Today we're going to be talking about Marbury versus Madison, 1803. Marbury was appointed a justice of the peace, but Madison refused to give Marbury his appointed papers. He asked the court to follow the Bureaucracy Act of 1789. Marbury should have been given his appointment papers, but the court could not force it because the Jurisdiction Act of 1789 was unconstitutional. And basically, the effect on today is established judicial review. Next one is McCulch versus Maryland, 1819. The state of Maryland decided to tax the second bank of the United States. And James McCulch, the bank manager, did not pay the tax, but you can't really do that because they're going to fine you and probably going to put you in jail. States cannot tax federal government because that makes no sense. This country taxes the states. The state can't tax the country. Basically, the effect it has on today is federal government is supreme to the government. Basically, day one, every time you go against federal, it always wins. It doesn't even matter because it has more power than you do. Next one, Gibbons versus Ogden. Kind of like this one because it kind of shows you what power the federal government has over regular state government. Basically, Ogden had got a ferry boat license in New York, but Ogden, or however you pronounce it, he got a license from the federal government, which basically overrides the state one. So basically, went to court. Basically, Ogden's won because federal. The next one is Dred Scott versus Stanford. Now, this might be a little bit touchy because it has something to do with slaves. Basically, the history behind this one is because back in the slave trade days, if you were in the South, you weren't a free slave, but if you were in the North, you were free. So basically what Dred Scott did, brought him and his slave, Stanford, up to the North. He didn't know that he could be free up in the North until he came back from the South, and basically he said, yo, what happened? I should have been free. And so he went to court. Basically, the slave master won because it was the South. But if it was in the North, it would have been a different story. Next one is Plessy versus Ferguson. People probably know this. I eerily remember it. It's called Herman Plessy, 1/8 black, challenged Louisiana law that mandated separate railroad carriers for blacks and whites because, separate but equal before it became unconstitutional. Then said, Plessy said the car designated to whites and was arrested because they don't care how much black you were. If you were like 1/12 black, they would have punished you like the blacks. Doesn't matter, you could be like whitest fella ever, but they looked at you, it would have got you. Shinnick versus U.S. 1919. Shinnick circulated a flyer during World War I, arguing to people to dodge the draft because once you're in the draft, you can't get out of it until you serve your time. Then, in favor of the United States, arguing citizens to break the law and pose the threat security of the nation is successful, clear, and present danger. First Amendment rights, as well as others, can be limited during times of war. Now, Korematsu versus the U.S., 1944. Korematsu failed to follow the Japanese-American internment, constitutional exercise of war powers, constitutional and executive act within their war powers. U.S. admitted the internment.
4 minutes.
Yeah, 4 minutes.